with chief judges swearing in newly appointed judges of Superior Courts of Record in their states, the same way and manner Honorable the Chief Justice of Nigeria swears in judicial officers of federal courts. Why must it be the governor that will swear in the judges? It suffices that governor will swear in the chief judge just as the chief judge will swear in the governor in the spirit of checks and balances. When it comes to the judges, the chief judge should perform the oath taking the same way the governor swears in the commissioners and political appointees. This is part of those seemingly innocuous practices that actually speaks to the issue of executive overbearing and over superintendence of the judiciary and activities. Another area of activity is that if the issue of judicial independence is truly to be taken seriously, it is suggested that moves should be made to remove the provision of judicial independence from the non-justiciable parts 2 of the 1999 Constitution as altered and be placed appropriately. It is rather unfortunate that an issue as important as the independence of the judiciary is rendered non-justiciable under the Constitution, the same Constitution it is meant to interpret and defend. The effect of this is and has been no action can be taken against or in furtherance of the push for the independence of the judiciary, such that even in the face of brazen distortion and desecration of the sanctity of its institutional independence as the third arm of government, no such question can be raised in any court of law. How odd. I think it is high time we, the members of the third arm of government, started analyzing this scenario more constructively. I will not blame those who hold the view that rendering the issue of judicial independence non-justiciable, it was probably never the intention of the framers of the Constitution that the judiciary should be truly free from the stranglehold of the executive and the legislature. It is suggested that all the clumsy provisions of the Constitution be amended to reflect a more clear and unambiguous provision for institutional and financial independence of the judiciary. It is my earnest prayer that those of us at the headship of the nation's judiciary will see reasons to align ourselves with this opinion and take steps towards actualizing it. No other organ of government can help the judiciary more than the judiciary itself. The judiciary must assert its independence through bold and courageous decisions and actions. The moment the financial independence is settled, a whole lot of other aspects of judicial independence will easily be sorted out. Appointment of judges and employees of judiciary, especially at the states, will no more depend on or be left at the pleasure of or whims of members of the executive arm. Not all heads of courts will be as lucky as some of us, whose executive governors demonstrate the political will to promote and support the independence of the judiciary. This is why I find it apposite at this auspicious time in the history of our judiciary that everyone, and I mean everyone in the judiciary, all stakeholders in the justice sector, and indeed all well-meaning Nigerians should rise and stand against the current bill orchestrated through a bill presently debated at the National Assembly to alter the Constitution in a manner that will be extremely detrimental to the true import and ideal of judicial independence we have so harped on and labored to attain all these years. If we keep quiet or fold our arms and allow this bill to see the light of day, then the Nigerian judiciary would have been finally captured by the political class. The bill under reference is a quote, a bill for an act to alter the Constitution of the Federal Republic of Nigeria 1999 to, amongst other provisions, transfer the power of the National Judicial Council to appoint or remove judges of courts, of state courts to the governor of the state, and amend the third schedule of the Constitution of the Federal Republic of Nigeria 1999 and for related matters. This pernicious bill seeks to divest the NJC of the power to make recommendations for appointment of chief judges and other judicial officers, judicial officers of superior courts of record, and its disciplinary control over such courts. The said bill, by implication, seeks to have domiciled all the powers of appointment control, and removal from office of state judicial officers in the office of the governor. The bill provides that the appointment of a chief judge of the State High Court, Grand Qadi of Sharia Court of Appeal of a state, and the president of Customary Court of Appeal of a state shall be made by the governor on the recommendation of the State Judicial Service Commission, subject to the approval of such appointment by the State House or Assembly. The appointment of other judges of state courts under them shall be made by the governor acting on the recommendation of the State Judicial Service Commission and no more. How dangerous this can be. I say this because we already know that the membership of the Judicial Service Commission, with the exception of the ex-officio members, are all appointees of the governor, who themselves are also politicians and political allies of the governor, including State Attorney General. It is true that the Chief Judge is the chairman of JSC, but what do we expect when the governor becomes the one with the sole power to appoint a Chief Judge without the input of the NJC? Would such a Chief Judge, who is governor's appointee, not also be the governor's man or even errand boy? We are also not unaware of the rub my back and I rub your back relationship that exists these days between the executive and the legislature in the most states across the country. So at the end of the day, the obvious truth is that if such bill says true, the governor becomes the one who appoints, exercises disciplinary control, and ultimately can remove a judge from office. It can be argued in favor of the proponents and sponsors of the said bill that Nigeria being a federation, the federal government, by interfacing with such courts through its agency, the NJC, is merely bringing federal control to bear on the federating units. However, we all know what the Nigerian factor is and can do. Drawing that clear and express distinction between the federal and state judiciaries will only pave way to multiple abuses to the peril of the judiciary. Imagine the scenario now that the NJC plays some contributory role in the appointment and removal from office of a judge. One can only imagine what the situation will look like when the quote, judges of all courts in the states lies in the hand of the executive, will then appoint and dismiss judges the same way he appoints and removes commissioners and political aides. Tell me, what will become of the Nigerian judiciary should this ever happen? What has happened to the doctrine of separation of powers? Obviously, constitutional democracy will then give way to absolutism and totalitarianism in most, if not all, states. Here is a wake-up call for the judiciary community in Nigeria to rise up with one voice to send this monster of a bill to its grave. Otherwise, there will hardly be anything left for the Nigerians to refer to as the last hope of the common man. The judiciary would have been taken many decades back and even far into the more deplorable experience that it ever had in terms of absence of independence. Still on the way forward, there is need to give more attention to improve judicial accountability by evolving stronger mechanisms for holding judges at all levels more accountable in order to curb corruption and heighten integrity and impartiality in the outcome of judicial process. It is also imperative to mobilize public support for judicial independence, especially in this age of social media. The actualization of this objective will receive more boosts with the involvement of the media, albeit the judiciary-made or homegrown media that can be controlled or closely supervised. As has been suggested, the judiciary, including all states, need the services of media and should create press units that will sanitize the public, or that will sensitize the public. This will be the tool to win support of interest and pressure groups that may galvanize the needed attention for the reforms to engender independence. In this quest for actualization of judicial independence, we must all continue in our concerted efforts to push for the autonomy until it is fully actualized. There should be no retreat and no surrender. I admonish all judges of the lower courts not to lose hope. The fact that certain remarkable progress has been made so far affecting the federal judiciary and judges of superior courts of record is enough green light indicating that time will soon come when the Nigerian judiciary will eventually attain full and all-encompassing independence. By the grace of God, we shall all be alive to witness it. Thank you for your kind attention.
Thank you very much, my Lord, for a well thought out presentation, which is very rich and has covered all the fields of judicial independence. Another round of applause for my Lord, the presenter. No doubt, this paper has covered all the areas of what judicial independence is all about. My Lord has used his knowledge and personal experience as head of court to bring out the challenges, to let you know what is going on, and to emphasize that judicial independence, independence of the judiciary, autonomy of the courts are aspects that are necessary for a real independence judiciary. Before we go into discussions and questions on the paper, I have a few remarks to make, some observations from some personal experiences that we have gained. He has covered adequately the principle of judicial independence, which is universal in nature. The entire world gathered in Bangalore and came up with the principle of judicial independence, which the minimum standard every country, every member of the UN must have in order to maintain an impartial and independent judiciary. Then coming home, what has our constitution said? How far has the courts interpreted that constitutional provision? Even in the military of era, you all know the Ojukwu federal government case where the Supreme Court asserted its independence by interpreting the constitution on the fundamental rights of citizens. Now, the Nigerian judiciary has come up with the code of conduct for judicial officers. That is also to strengthen judicial independence, because the presenter has adequately covered external, internal, individual independence. So the essence of the code of conduct for judicial officers is to ensure that individual judges maintain the independence of their mind, of their court, of what they do. He has adequately covered the challenges, and it shows that it is the judicial community that itself must assert that independence, must show the world. I could recall that during the IBB era, when the set of civilian administrators were going to be sworn in, I was then the chief registrar. I told the chief judge that I have changed the folio of your car, the plate number of your car. And why should you do that? I said, because we are going into democracy and we are independent of the judiciary, I mean, of the executive and the legislature. So we were the first to implement that, but then we took it to the body of chief registrars and everybody implemented. Until then, Ministry of Education will bear the same number, state government, or federal judiciary will the CJN will wear FGN, blah, blah, blah. Now it is a different story. FGN, federal judiciary, and then the folio will indicate whichever court is there. So it's one way of asserting your independence. Then coming home, all of you have to go to the clinic or hospital somehow, somewhere. And it occurred to me, actually something happened that was nasty. My lord was in Katsina on the election tribunal panel. One of them was sick and had to be taken to the clinic. Somebody suggested that he should be taken to Government House Clinic. And he was presiding over the governorship election tribunal. I said, how could you do that? Then the idea came to me, we must have our own clinic that will cater for judges, magistrates, and judicial officers. And so we had it. It's all about initiative. Now you go, you don't have to join queue with accused persons and witnesses. If you go to the general hospital or federal teaching hospital or federal medical center and you are on the queue to see a doctor, and then behind you or ahead of you is an accused person or a witness who turn around and said, your worship, please take over this. When you come and meet him in the court face to face, how do you feel? There was an incident where a magistrate, his wife was in labor, mid of the night. There was no way he could get to the hospital until somebody, the security told somebody to come and help his wife. And that somebody was an accused person. He had to take him to the hospital. And when the story came to me, I said, God willing, every chief magistrate and every Upper Sharia court judge must have a vehicle, at least an official one, to do his thing. And that was it. And each one of us will create that impression and carry it along. Of course, I said, of course, you must strike a balance between asserting the independence. Yes, truly judiciary is independent, but it's not devoid or completely cut off from the other arms of the government. No, you must coexist together. You must help each other to, but for the court to be independent, yes, it is the individual judges, and you must help in creating that independence. The only challenge or problem that my lord didn't mention is the role of the bar in helping the judiciary attain its independence. In a way, it does help, but in another way, it is the biggest problem of eroding the independence of the judiciary. If an attorney general will have to tell his governor that, look, we must take over everything. If you allow this judiciary, they will make your state ungovernable. It's sheer stupidity. Attorney general, the governor will always stay there. As a lawyer, you still come back and need the judiciary to work with. So sometimes you have to, of course, when you get to the Judicial Service Commission, Attorney General is one of the statutory members. So the head of court, the CJ in particular, and at the state level, the High Court, the Sharia Court, and the Customary Court, or any of the courts that is allowed by the Constitution, the heads of courts must come together, act together, remain independent. Otherwise, the executive will find a way in their differences and penetrate the judiciary. So the floor will be open for discussion, and my lord will be ready to take your questions and comments. But I'll begin with the high table. If any of the members of the high table has any comment to make, and of course the administrator. Otherwise, okay, the Honorable Grand Kadi, please.
Okay, thank you, my lord, for the opportunity. My lord, the chairman of this session, permit me to thank and appreciate my lord, the presenter, for well-researched and well-delivered paper. We thank you, we appreciate you. I just want to seek the attention of my lord to page 28 of the paper. I think paragraph 1, 2, 3, where my lord mentioned the caddies among the magistrates and the lower courts, lower judges of the lower courts. And constitutionally, the hierarchical order is the caddies and my lord of the high courts are in the same status constitutionally. I can see the presenter mention caddies among the magistrates and the judges of the lower courts. Thank you, my lord, for this opportunity.
Yes, I'm sure my lord means no offense in doing so. We'll get it corrected. But his understanding as a professional cadre of Sharia courts, all judges of Sharia courts can be referred to as cadis. But under our law and constitution, the Qadis are separate from Sharia court judges or area court judges, as the case may be. Thank you. I hope that this clarifies, my lord, and other participants for understanding of the issue. My lord, any other comment from the high table? Otherwise, my lord, the administrator. Comments from the participants, I think we'll take it in order of precedence, in order of convention that has been said. From that side, anybody? In the absence of anybody, then we take from this side. Your name, your state, your court, and then your comment or question, please.
My lord, the chairman of section, my lord, the paper presenter, and my lord, members of the high table, distinguished participants. My name is Collins Godfrey Ali. I'm from Rivers State Judiciary. I'm a chief magistrate. I want to thank my lord sincerely for a well-presented paper. It's rich. My lord, I've looked through the paper alongside your presentation. You made quite a insightful contribution in your paper, and then felt for us, the lower court judges and magistrates. I looked forward to, particularly at that page 28, when you acknowledged the recent improvement in the retirement age of judges of the superior courts, and then the improvement on salaries, and said, you gave us hope that we should be hopeful. I was looking forward to a suggestion, and I want to make that suggestion that efforts should be made to increase the retirement age of magistrates and judges of the lower court to 65 years at least. That will give us an area of hope. In terms of financial benefit also, Lord, we are advocating that the authorities lend their voice so that we also get an improved financial packages to give us hope in the services that we render as magistrates and judges of the lower court. Thank you, my Lord, for that presentation.
My response to the correction made by the Grand Cadi is that it is well noted. It was not intended, like the chair said, to malign the office of the Cadis. I was given just less than 1 week to prepare this paper. That accounts for, and again, the area I practice. So the tendency was to mix it up. But however, since I mentioned all judges of the lower court, it should be construed a jus generis and remove by pencil rule those that are not supposed to be there and allow those that are supposed to be there to be there. Now, Godfrey Collins Allen, you see, what you have suggested is indeed, or has indeed been taken up by several jurisdictions. I know that in my state, Ebonyi State, the magistrates have made presentations in respect to increment in the number of their tenure, that's to 65 years, and then improved salaries. I read through it, and the only thing I asked them to do is give me instances of states that are taking that bold step. And I will package it and take it personally to the governor and argue for its implementation. They are, as we talk now, as we speak, they are on it, because I'm told that one or two jurisdictions have implemented it. Once they give it to me, be rest assured that Ebonyi will be the next to increase the tenure. Thank you. And I'm also one of those who say that the salaries of the magistrates and all others in that cadre should be improved. We started with the customary courts. Today, as we speak, the salaries of all the customary courts chairmen and members have been enhanced. So the next challenge is that of the magistrates. And once they get me, for me what I asked, I'll pursue it and I'll get it. Thank you. So in all, it depends. Present this your views to your head of court. Your head of court, we are all one. We cannot exist without you. And so if you make the presentation, every head of court must look into it and then see a way to, present it formally to the chief executive. That's what it is for now, until NJC is bolstered to taking care of everything concerning the judiciary. In that case, we will only have to present it to the CJN. But for now, we have to go quote and unquote, cap in hand to the executive to ensure that we get what we want. Thank you.
Thank you very much, my lord. Before the comment of my lord, the CJ Kwara, let me also add. Now, my lord has spoken. The welfare and working environment of magistrates and other lower court judges is extremely important. Now, all heads of courts probably were at one time magistrates like myself. I rose from grade 2 magistrate to chief magistrate, served as chief registrar. So I know all the things that you go through. By way, whenever you have the chance, whenever the budget comes up, what you do, look at what you can enhance. Think out of the box, look at what you can enhance. Like the issue of these vehicles, yeah. Then you move ahead. Medical allowances, what can you offer to magistrates and area court judges or area court or customary court judges as medical allowance? Rob allowance. We have all started implementing these without actually any law or using any statute to do so. By implications, once the aspect to become judges or caddies as they retire, but we are very close to the time. We said, look, we will give you the opportunity. Since the NJC guidelines said you must have at least 5 years before retirement. So if you had retired at the age of 60 and you still have 10 years, you will be given the opportunity still to. Hitting the executive or the legislative has some input to make.
I want to specifically join others in appreciating the paper presented, the CJ of Ebonyi State. It was indeed a well-delivered paper. I congratulate you. I want to make input on 2 areas. The first has to do with the suggestion made by one of the magistrates. I want to say with great emphasis in fact, some set of magistrates were at the verge of retiring in 2 in 2020. As a result of that increment, as a result of that law, they enjoyed it and they were appointed High Court judges in 2020. So it has happened in some states. It has happened in some states. Kwara State is a very good example. Then another aspect I want to touch has to do with individual independence with the resources in this paper. There's one tiny area I just want to make independence. Is the judges of the lower court. Responsibility. It is always good to have a listening ear. Be patient in listening to the two sides that are cast before you. If you imbibe this attribute, it will help you so much rather than interjecting, asking questions, unnecessary questions when there's no need for it. It will help you when you go back to the recess of your chambers to write your decisions. It will so much help you. It doesn't show any brilliance when in the open court you begin to ask questions over and over. It only shows the type of person you are. And easily, the litigants will know the side in which you are going. There's no need for that. Most importantly, we should not be carried away. We should not have any kind of fear in our mind when any senior member of the bar comes before us. Yours is to listen, get down as much as possible the evidence given in the open court. But when you begin to talk too much, these are senior members of the bar will try to play on the intelligence of the judge or the magistrate. That is unnecessary. So the act of listening patiently, respond courteously, and decide soberly is very important in the day-to-day act of carrying out your responsibility. This is very important. Thank you so much.
The administrator, I think I must mention one thing. From my experiences, okay, we'll soon join the online participants. Sharing these experiences, it's very good. On independence, individual independence, I must comment that my observation is that when you see problem or petitions, more independent, more forthcoming, and more compliant, more upright. But that is what the researchers here to do. In other words, whenever you have petition against grades, 10 petitions, 9 will be against the male. But I want to comment you and ask you to keep it up. Line comments and question, but before then, My Lord here will want to give some contribution, please. Those coming online, please get ready.
Sadiq Usman Mokhtar. The Grand Cadre of Kebbi State. The paper presenter, you have done well. And we really appreciate your paper. You've got to answer a prayer so that we can witness. When you go to them, they listen to you. And some governors, we all know, they are too bad, too powerful, too arrogant. They can't even listen to you. So it's good that at the state level, or as they have this magistrate association, this area called lower court association, all their problems, they can write it. And we also will know it, so that we can meet the Chief Justice of Federation, especially the question of judicial officers. I don't see why a magistrate or an area court judge or lower court judge cannot be recognized as judicial officer. They are supposed to be recognized, and all the work, the work they are doing at the grassroots. So, my Lord, thank you. I think they have the most problem that I have been one, the question of this retirement age. When we will retire at 70, they are not supposed to go at 60. Let us be candid. Second, the question of remuneration. They are poorly remunerated. So, SARS, instead of at different states to go on their own, Mr. Chairman, you are one of our leaders and other head of courts. Let us pursue and try for them. Thank you very much.
Thank you very much. Before I give it out to the presenter to comment, I have this notoriety for being very old in the judiciary, for having seen so much. Now, when you talk of lower court judges and magistrates being judicial officers, they are from all purpose and intent. The Code of Conduct has addressed them as judicial officers, separate from judicial staff. So what applies to judges of the High Court, Court of Appeal and Supreme Court also applies to them when they sit as judges and magistrates, because that is where bulk of the work is. So it's about you asserting your independence. As for the politicians, we want you to be independent of them, to keep away from them, because there was an association of Sharia court judges that sought to see the governor at the time of election. I said, look, we are not against you seeing them, but what will the public perception be that you have gone to see the governor? So see the head of court, see the CJ and stop there. If there is anything, we are more concerned than you are over your welfare, over your working environment. Or because if you said a high court judge should have access to internet, to have, why shouldn't a magistrate or Sharia court judge have it? So on these things that affect the court, you are entitled to, and you must be provided. So we have licensed you, the magistrate, we have licensed the Sharia court judges on different platforms, and you are entitled to all these things. Participants, if they are ready with their questions or comments, can the technology team please link us up to them?
Thank you, the chairman of the session. I've listened to the views expressed by the Grand Cadi of KB State. It's a welcome development. However, I must say that while the Magistrates Association and other judges of the lower court are encouraged to have an association from which they can make their views known to their various heads of courts. It is a different thing, as my Lord the Chair has pointed out, for them to move beyond having these meetings with the heads of court to proceed to the chief executive. Once you take that step, you are deemed to have sold out. The head of court is empowered to do so, to meet with the governor, because first and foremost, he's a political appointee, quote and unquote. He's the only person, political, in the sense that he's the only person permitted to pursue your cause with the other arms of government. We did that in Ebonyi State. When I came on board, the sorry sight painted by my Lord the Chair was what was obtaining everywhere. A scenario where you see a magistrate heading to court without a vehicle and then entering the same tricycle with a litigant in his court, or sometimes entering a bus with a litigant in his court. I mean, such sorry sights, I couldn't contain it when I came on board. And I approached the governor as soon as I was made the chief judge. And the governor, in his magnanimity, gave a listening ear to it and bought brand new SUVs for all the 47 magistrates in Ebonyi State. So I believe these things are doable. All you have to do is to make your case known to the, not that he doesn't know about it, not that each head of court does not know the plight you are going through, but you are in, if you don't say here I am, indeed nobody will say there you are. So I urge you to make your presentations, just as, like I told you, the magistrates have written to me, urging me to intercede to cause the age of service to be increased to 65. Before now, I didn't know that any jurisdiction had done so. So I asked for instances. So now that I have I have it on good authority that it's been done by Kwara State as far back as 2019. Be sure that maybe by the next time you come for your conference, you see that the Ebonyi State has joined the bandwagon. So that's the way it is. So I encourage other judges of the lower court, don't keep quiet. Don't say the head of court knows our plight. Put it down in writing. As an association, put it down in writing, addressed to your head of court. The head of court, if he sees through it, will now make the presentation to the governor, and they almost always, because they cannot do without you. If all the magistrate courts, all the area courts are grounded, there will be anarchy in such a state. Believe me. So they know, although we are not allowed to go on a strike or strike, but it is true that if for any reason, in any setup, you people don't work, there will be anarchy. So they would dread it. And so just write and allow the head of court to take it from there. And then I must also tell us why I referred in the paper. There's light at the instituted an action and won. It only remains the implementation. So what I think will also happen is for the various heads of court too, armed with this judgment. So because it's not against the federal government, it relates to us, all the matters relating or peculiar to each state. Each head of court should be armed with that judgment and pursue the cause with the government of each state. Say, look, there is a binding decision of a court of appeal on this. Implement it as regards the magistrates and other lower courts in the state, and indeed the staff of the entire judiciary. If we do that, I believe they always ask. If you ask to tell the governor, particularly, we ask his colleagues from other states, are you aware of this position? If they say yes, how did you treat it? They will tell you. So be the first to notify your governor so that when he is asked, he will say, yes, I'm aware. I'm discussing with my chief judge as to what will happen. In other words, create the awareness, make these things to come to the fore. That's all that is required. Thank you.
And in pursuance of the improved welfare of judges of the lower courts, I must tell you that heads of courts are planning to institute a process whereby we move from one state to the other. We can go and see the governor, tell him we are here for courtesy call, to appreciate him, to ask him that so many states have done this, we want you to do this. Somehow it's a way of getting around and getting it from them. They can be overwhelmed when all chief judges and heads of courts are before the governor, saying we came to pay a courtesy call to you. We appreciate what you are doing for the judiciary. Please, we understand that you have not implemented the increment in the years of magistrates and lower court judges. Please do it. He will commit himself there and then it will be done. That is another way of doing it. My Lord, you have some comments to make, and I'm awaiting the virtual participants if the technology team can open them and let them make their questions and comments.
Thank you, my Lord, the moderator. My name is Tajuddin Abdugani, the President, Customary Court of Appeal for your state. You know, for us to have this independence, true independence that for us to have this true independence that we are clamoring for, there is the need for the court itself to be united. The situation we are in the state, the arms of courts are not on one pitch. The situation where, for instance, the chief judge, being the head of the entire judiciary, goes to see the governor and forget the other arms of court that are in the state, collect all that are collectible for the high court and even the magistrate court, under her. I think this is very, very unfortunate, and there is no way we can move ahead. So I want us to maybe talk to ourselves as the head of courts, especially the chief judges, so that whatever they are, they should see themselves as the head of judiciary, not the head of the high court alone. So that whatever they are going to the governor, they should either carry the other heads of the arms of court along, or at least they consider the plight of the judges under him when they are making their request. Thank you so much.
Well, I have a privileged information, my lord. The current CJN is trying to address all heads of courts and tell them the importance of their unity because the executive capitalize on these differences. You know, head of court going to talk to the executive against his colleague head of court, and so that he will get advantage. That should be over. The CJN has promised to address that, and very soon too. So online participants, you are not coming on, and comments and questions or comments, please. Yes, yeah. Again, your name and your state and your court, then your question or comment.
Yes, my lord. Thank you, my lord. Adebi Adoremi is my name. I'm from Oyo State. I'm a chief magistrate. I humbly appreciate my lord, the Honorable CJ, for the good lecture we have received today. However, my lord, the issue of welfare, as long as we understand that payments of salaries and welfare forms part of welfare, welfare is also not limited to payment of salaries for magistrates or judges of lower court. Part of welfare, I believe, should involve the room for career progression. Rather than having magistrates stop for years as magistrates and all that without being considered for elevation, I think is what needs to be reviewed. When the opportunity came during the last conference for reform, and I believe the conference was held in this hall, the communique issued at the end of that conference is quite discouraging for the career progression of the magistrates, particularly paragraph 15 of the said communique. With my Lord's permission, I seek to read out from the said communique read out from the meeting held in this hall. I'm sorry, my Lord. Yes, my Lord, paragraph 15.5. A, addressing magistrates' concern. The president of the Magistrates Association of Nigeria noted that the current appointment process and the proposals for its enhancement would put magistrates at a disadvantage, as they would not have the technical skill and knowledge required for the appointment of the Superior Court of Record. In response, the summit resolved that the president's observation underscored the reason why magistracy should not be seen as why magistracy should rather be seen as a separate career path and not necessarily a stepping stone to appointment as a judge of a Superior Court of Record, as the qualifications, experience, and skill sets required for these offices differs. My Lord, I humbly commend this paragraph of the summit's communique for kind consideration, because if they say that the requirements and the skill sets differ, then can we understand the requirements and the skill sets of the Superior Court? So that is my own concern. regarding the welfare. And on the issue of tenure elongation of year of service for judges of the lower court, I'm happy to also acknowledge that that has also been achieved in Oyo State, and it has 5 years, and I'm aware Osun State has also achieved that feat as well. So please, my Lord, I really seek clarification on that, sir. Thank you, sir.
It's okay. My Lord has extensively spoken on career progression, process of appointment. You see, we've reached a stage where all interested candidates from not but from the private bar, from other academia, from other institutions like the NGI. A good number of our judges now are staff research fellows and academic from the NGI. And a good number of judges are also from the area of legal practice and the Ministry of Justice. When it comes to appointment to higher bench, the guidelines are very clear. But as far as I'm concerned, magistrates have more advantage than all others because they are at home. What is required is 10 well-considered judgments, and they have been there. So the disposition is that even at NJC, unless you don't use your experience and your knowledge of the law, of course the NJC will always prefer quality than years of experience. Certainly, it is the NJC that has the final say, but magistrates are always given more opportunities, at least in some of the states I know, than all others. So I think there is no question of that. What we were talking about when we said the welfare is the working environment, working tools. Every magistrate should have access to internet, must be given computers. At this time and age, should as much as practicable be given an official vehicle. Should as much as possible have access to medical care privately, either by arrangement or the judiciary should have its own health facilities to cater for judicial officers of all levels. And like I said, we have been battling over this. We will get there. You just have to play your own role. With or without all these facilities, you have chosen to take off out of office, and you are bound by that. If they come, good enough. If they don't come, you keep on pursuing. But nobody stops you from saying, look, I cannot bear this job. Let me resign so that I don't bring myself in refuge with the system. Any other comment? My Lord, I think you have already responded to that. Okay.
My lords, I just want to lend my voice to what the chair of session has said with regards to the views expressed by Aderemi of Oyo State. I want to lend my voice to the fact that it is not true that magistrates are not considered for purposes of elevation to the higher bench. I use my state as an example. In Ebonyi State, a year ago, out of the 6 judges that were out of the 6 persons that were elevated to the to become judges, 5 of them were magistrates. Only 1 came from the outer bar. So it is not correct to say that magistrates are not. Indeed, in Ebonyi State, the first consideration is the magistracy. Thereafter, the outer bar. Then the last but not the least is the academia. That's the way, because we conceive that the magistrates deal with the law. They are already in tune with how judgments are written and all that. So they can adapt more quickly than even lawyers from the bar. That's the consideration. So it is not correct. The only thing is that we follow the guideline of the NJC, which says that for you to become a judge, you must have attained the position of a chief magistrate. Outside that, there is no other impediment. So, like he pointed out, my Lord the Chair pointed out, all you need to is let your pen speak for you. Let your judgments be your voice. You will not be there when these things are considered. We consider them a lot. Indeed, there was one of the persons that was elevated all through her career. She had been in the remotest parts, but her judgments spoke volume for her, and she was number one on that list. So don't be discouraged by where you find yourself. Don't be discouraged by what you see. Let your pen speak for you. Write your judgments as if your life depends on it. Even where internet facilities are not being provided, don't wait for it to be provided. Some states are lucky to have it done for them. If you are not that lucky, don't wait. See how you can manage to get it, because it's a tool that you need today. You must have the law pavilion. You must have it. So if you have it, your work will be easy. For every issue of law, tap into it. It gives you authorities that will help you navigate through the facts that are before you. So I encourage you not to give up hope. There's light definitely at the end of the tunnel. Thank you.
Thank you very much, my Lord. Okay, while we are coming to the end, more comments are coming up. Okay, let me take the comments of the two ladies there and we round up, please. Give the lady there, yes.
Thank you, my Lord. I'm Oluwatoyin Igbobo from District Customary Court, Osun State. My question is this. Over the time, we have been seeing that President of the Customary Court of Appeal comes from the High Court, but we have never seen anybody crossing from District Customary Court to the High Court. So we don't know what is really happening to Customary Court of Appeal and District Customary Court when it comes to career progression. So I need much explanation in this area. Thank you very much.
Yes, I think before I give the presenter, I want to tell you that there is no hard rule about it. Incidentally, going to the superior courts is not by development. For instance, we have a good number of grand caddies. I can be sure that of Kasana, that of Kebi, that of Kano and Kwara have all been chief magistrates before they become grand caddies. So you can see there is no hard and fast rule about it. Customary, all the states that have been there, customary court judges are, it's the Constitution has defined the criteria, the qualification of those who are supposed to become judges of the customary court of appeal. And it is clear that they can aspire from district customary court judges, from Sharia court judges to become caddies and become judges of the customary court of appeal. So that I am sure of. And I think if you wait in your state, you might reach that position. Maybe the presenter, you have anything to add on that?
Just to say that it depends on the law of each state. For instance, in Ebonyi, the constitution of the customary court is one, the chairman must be a lawyer. The two members of the court are not non-lawyers. And so, but there must be persons that are seasoned or learned with the custom of the particular place. That's why they are appointed. So it will become, therefore, difficult. And there are tenura. Their office is tenura in my state. They serve for 2 years. Recently, it's been increased to 3 years. And so, within the 2 years or 3 years, they are considered not just as chairmen of customary courts. They are principally considered as lawyers, first and foremost. When they deliver judgments, their judgments count for them when they apply to be members of the higher bench. The judgments are considered, the case they also have, because they are entitled by the law to still practice as lawyers. So if they take along the judgment they delivered as chairman of customary court, add it to the cases they have done at the high court or other courts, and then that will count for them for purposes of elevation. So I do not think there's it has a disqualifying effect at all. As regards movement from membership of the customary court of appeal to becoming heads of court, or movement from the high court to becoming heads of the customary court of appeal, it is not practicable in my state. In my state, the career progression, the movement must be from within the customary court of appeal. No person from the high court can move to the customary court of appeal, and vice versa. No person from the customary court of appeal can become a chief judge in my state. No person from the high court can become the president of customary court of appeal in my state. So if you are in the customary court of appeal, you rise from there, and from there to the court of appeal. Indeed, one of our judges from the customary court of appeal was, or is one of the, or is the first person from the customary court to be elevated to the court of appeal. And she's in the person of Uche Onyemena. So there is no inhibitions at all. The career progression is there. Thank you.
Thank you very much. The last comment, please.
Thank you so much, my Lord, for this opportunity. I am directing my question to my Lord, the President. We can use it as a case study when fighting for our own welfare in our various states. So that is what I want to know, my Lord.
Thank you very much for that beautiful question. First of all, I pointed out that the office of the chairman of customary court is tenurial. It is just for a period of, it used to be 2 years, but now it has been increased to 3 years. The question is, do you equate someone who has just 3 years to be in office with a magistrate who has to stay for 60 years in office? The answer is no. The only thing, I'm sorry, but that is the truth of the matter. So what we have done in Ebonyi State, like I pointed out, is that we saw their remunerations and we say, no, things have changed. and we increased their salaries from what it used to be to what it is now. So that is what we have done for them. And like I pointed out, they are viewed, as far as we are concerned, what they do in the customary court is used to augment with what they do as lawyers. Therefore, their judgments in the magistrate court are added to, or considered. For instance, if you have 10 judgments from the customary court of appeal, well-reasoned judgments from the customary court, and you are applying to be elevated, you will not be disenfranchised because they are judgments of the customary court. No, it will be considered just alongside as those who are magistrates, the judgment they delivered at magistrate. And in the same vein, it will also be considered as judgments received by lawyers from the outer bar. So you lose nothing for purposes of appointment. But in terms of remuneration, I'm sorry, we have not done anything other than increasing the salary. As to the vehicles, we have not pursued it, apparently because there has not been an awareness, or they have not made any presentation to me on why it should be done to them, because as it were, they are kind of part-time, as it were. Because if you are given a tenure of 3 years and allowed to still practice your law, you can't be equated with a magistrate who, upon appointment, can no longer go to the bar and take up cases to do. So they are different. So that's the challenge people who are chairmen from Ebonyi encounter. It's not meant to disparage them at all, but it's the nature of the law under which they are practicing. Thank you.
Well, I will keep on opening and opening and opening. We are just on time, and we wouldn't want to breach the procedure. We are actually going over by 5 minutes. So as the discussions continue, other presentation will take care of your questions and response. I want to thank the administrator for giving us this opportunity to have this session and the presenter for a well thought out presentation. My Lord, excuse me, my Lord said on the high table, you have done well. And I think we are all enriched by the paper and the discussion that followed. A set of courts, just wait for us to see what we will do as a fallback of this paper. Once again, I thank you and hand over to the MC for some announcement and house rules. Please.
Thank you so much, my Lord. Please, a round of applause to His Lordship. My Lord, we thank you immensely and profusely for agreeing to moderate this session. It was an impromptu decision, but despite the busy nature of your work, you accepted to do so. We're indeed very grateful. So please, another round of applause to His Lordship for that. And another applause to my Lord Justice Elvis Ngene, the Chief Judge of Ebonyi State, on this very vivacious topic that affects the judiciary at all levels. I want to indeed thank all the heads of courts who are here present for adding color and for making the various incisive contributions to this segment of this session. We thank you indeed, my Lord. Please, a round of applause to all the heads of courts who are here. And permit me to make a slight clarification by way of an apology. In the morning, I announced a wrong person as the Grand Cadi of the Sharia Court of Appeal of Kano State. I want to correct that, my Lord. My Lord is here. He was among the first of the heads of court who made interventions as to the issue of independence. My Lord, I'm talking of my Lord, Honorable Kadi Tijani Ibrahim Yakasai, who is the Grand Kadi Sharia Court of Appeal, Kano State. My Lord, thank you very much. A round of applause to His Lordship. I want to thank my Lord Kadi Mohammed Kigera, Grand Kadi Sharia Court of Appeal, Niger State, who is here too. He joined us while
conversation was going on. So we thank you so much, my Lord. And to you participants, the conference is actually yours, and without you, there wouldn't have been any conference. So I want to thank you for the rapt attention, engagement that you've all had. .30 to 8:45 to convey you and bring you here to the auditorium. I mean, for those who are residents in the hostels and the accommodations that are offered by the Institute for this event. So you do well to be tardy so that we can attend punctually. I have some misplaced items here. We have a ring. It was found during the photograph session. So if it is yours, please do endeavor to meet with us to collect. And we have an earpod here as well. So if it is yours, please do meet with us to collect. My Lord, in the absence of any other engagement, having exhausted the items on the program for today, I wish my Lord, having exhausted all the items on the agenda of program for today, I wish to humbly call for that the sessions for today have come to an end. We are all dismissed to come back tomorrow. Lunch is served. Please enjoy your lunch and have a quiet, peaceful night rest. Thank you. Good night. Yes, 9 o'clock, please don't forget, like I've said, 9 o'clock tomorrow, we are starting, 9 o'clock.